there, everybody. Abide with me. It's going to happen to us someday, folks. Just be joyful that it isn't today. I uncovered some more corruption. No. That's good. And this is in New York State District Court in the county of Nassau, Long Island. The only district courts for the state of New York are in Long Island. Nobody else has district courts. Isn't that funny? And I tried to file my lawsuit there, Glendora versus Diane Bennett and Elisa Amato, and it would have only cost $20. And their clerk there, named Robert Szymanski, kept finding excuses not to file that lawsuit, and he kept sending back the complaint. And so then I wrote a memorandum to his boss, Judge Scher, and that I thought my civil rights were being violated, and also public law 94-426, that he had to file my petition. And apparently he intercepted the letter, and it never got to Judge Scher, and I never heard from her. And so I had to file the lawsuit, so I went to the Supreme Court, the county of Columbia, state of New York, and filed my lawsuit there. And instead of costing $20, folks, that cost $315. Well, there was a good thing about that. In the district court in Long Island, you can only recover, the maximum jurisdiction is $5,000. Whereas in the Supreme Court, County of Columbia, I sued for $23,000 because they don't have a limited jurisdiction that I know of. Monetary jurisdiction. And that turned out to be a good thing because both Bennett and Amato and their screwball lawyers, Sadly Stevens, Burke and Burke, Robert Callaghy, and Walter Swarock, are in default. They had until the complaint and summons with notice was served on them Christmas week, and Kelly Bernas served it in person. This is indisputable service. She served it to him in personam, and her father, James Bernas, witnessed it. Both of them, Alyssa and Diane. And they were supposed to answer in 20 days. That would be the middle of January. Well, they didn't answer until the middle of February. So they're in hopeless default. But I sued Mr. Szymanski, and I sued Judge Scher for violation of civil rights. They are state actors. They do work for a government, the state government. And so Mr. Szymanski tries to pull a fast one, and when he gets a complaint that he sued, this was filed on April the 21st. It took 6 months to write this complaint. Instead of answering the complaint, saying he denied it, he sent my complaint back and said, send $45 if you want to file this complaint. Well, does it say the U.S. District Court up there in Hempstead? I mean, does it say the New York State District Court in Hempstead? Does it? I don't think so. I think it says the United States District Court in the District of the United States Virgin Islands. So I think Mr. Szymanski's pulling another fast one. So I took his complaint and I put it in a great big 9x12 envelope, and I wrote on the outside of it as follows. It is addressed to Shemansky and to Denise L. Scher, the judge. And I say, you have been sued. The complaint Glendora sent you is about you. You have been sued in federal court for violation of Public Law 94-426. Inter alia. Glendora is returning the complaint to you. You are listed in the caption on page 3. You had 30 days to answer. Today is May the 12th, 2006, and you have just 9 days to answer, or judgment by default will be taken against you. Federal Rules of Civil Procedure, Rule 55. My case, which you so vexatiously refused to file in your court, I had to file in County Supreme Court, State of New York. Defendants Bennett and Amato are in default at the time of $23,000. Yours in truth and in amor patriae, love of one's country, and amor New Yorki, love of New York. And that has been served. Now, we go on to more corruption. In the Second Circuit. Federal Court, U.S. Court of Appeals for the Second Circuit in Manhattan. And I filed a judicial misconduct complaint against the chief judge there named John Walker. John M. Walker Jr., I believe. And guess who he is? Yes, John M. Walker Jr. He's the cousin of George Bush. Received by Glendora on May the 6th, 2006. Memo endorsed by Glendora on May the 12th. And it says in the charge, in re the charge of judicial misconduct, it's against John Walker, and it's against the United States District Judge in Manhattan. And it was so long ago, 3 years ago, I've forgotten who that judge is. And I'm not going to spend an hour or two going back into the files to look it up. And they have misused this stamp for years. I have seen them misuse this stamp for years. And they say that complaints having been filed on March the 10th, 2003 and April the 9th, 2003, a month apart, alleging misconduct on the part of a circuit judge, that would be John Walker, and the district judge, whom I've forgotten, of this circuit. And the complaints having been dismissed on January the 18th, 2006. It took them 3 years to do the job, or not do the job, on those complaints. 3 years. And they were dismissed by the acting chief judge of the circuit, who is Guido Galabrese, who is a judge in New Haven, Connecticut. And a petition for review, when Calabrese dismissed my complaint, I filed a petition for review by the Judicial Council of the Second Circuit, which is a hodgepodge of some circuit judges and some district judges, and it changes all the time. A petition for review having been filed timely on March the 19th, 2006, upon consideration thereof by the council. And Glendora wants proof that they considered it. I don't believe it. It was a fix. Ordered that the petition for review is denied for the... Is anybody surprised? Is anybody surprised that if you complain about a judge and it's going to be reviewed by his buddy judges, that it's going to be denied? Are you really surprised? Ordered the petition for review is denied for the reason stated in the order dated January the 18th, 2006. And I went over that with you with a fine-tooth comb. Everything that Calabrese said, I pointed out every lie, every deceit, every cheat. In fact, I have caught the Second Circuit in over 300 cheats. Do you hear me? 300 cheats? Now, when they say it's an order, do you see this signed by a judge anywhere? Is that a judge? I don't think so. It's an employee. This is not an order. This is a nullity. It is not signed by a judge. It's not an order. It is not signed by a judge. And the clerk is directed to transmit copies of this phony order to the complainant, moi, and to the circuit and district judges. That's Walker and the judge whose name I forgot. It's a long time ago. Well, I say, what do you do when the judge doing the judging? What do you do when the judge doing the judging is as bad as the judge being judged? Folks, you could not pay me to sit in an office all day and violate the Constitution of the United States Code, and the appellate rules of procedure. You could not pay me to do that. They have no problem taking money, your taxpayer money, for that. No problem at all. Just sit there and cheat and lie all day long. This is patent. 18 Criminal Code, U.S. Code, Section 1001. Misrepresentation of material fact. Now you see why they denied the petition? Because they can't face it. They can't take it. They're running away. You couldn't be more cowardly. They are running away. And they look it, and it's indisputable. Now, this, folks, is a monumental victory for Glendora. She has worked years to expose the corruption in the Second Circuit. So, this is a total capitulation that they know they're corrupt, and they have no answer, and they have no defense. But it's a dismal failure for America. It is fraud. And so here is the Judicial Council complaint, dockets number 303-8526 and 03-8531. It took them 3 years to act on it. They were so ashamed of themselves. And they don't call me by the right name. Their caption captures, the name on the caption is Glendora, and they don't call me by the right name. They can't read a caption. I tell them to get it straight. And another thing too, they will not let us handle 2 complaints on the same paper. You have to file different papers, but they do it. They double up, they piggyback. And then they say, pursuant to the rules of the Judicial Council of the Second Circuit, governing complaints against judicial officers under Title 28, U.S. Code, Section 351. You know what that is? It's an obstruction of justice. Everybody in that court down in Manhattan is an obstruction of justice. And that's Title 18 Criminal Code 1505. And it's signed by Roseanne McCackney, and no, it isn't signed by her. That's bad too. It isn't signed by her, so that's a nullity twice. It's signed by Patricia Chin Allen, who's a flunky who will be gone probably within a year. And what are the names on the Judicial Council? Another cover-up. Another 18 U.S. Code. Section 1001. Cover-up, cheat, lie. Well, who are they? In Title 28, U.S. Code 351, is the Judicial Reform Act of 2002. Well, we need another Judicial Reform Act, Congress. We need one that they can't wash out. We need a permanent, indelible, marker type Judicial Reform Act. Not one that's washable. Discussion with these people. I guess it's kind of obvious, isn't it? And I want to just read you fraud. Fraud, and this is exactly what they did. An intentional perversion of the truth for the purpose of inducing another to relinquish some valuable thing belonging to him or her, to surrender a legal right, a false representation of a matter of fact. This is what you did. Calabrese, Walker, McKechnie, and all of you hoods there. This is exactly what you did. Whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed. You did this, Second Circuit, which deceives and is intended to deceive another, so that he shall act upon it to his legal injury. That's you, fraud. Second Circuit. I feel so sorry for those people. So I sent a prayer down to them. The prayer is written herein on its musical score, but to you, I can sing it. So I sing this to you, John Walker, in all sincerity, and to you, Calabrese, and to you, the U.S. District Judge I complained about. It's been so long ago I can't remember your name, but I could look it up. And to McKechnie, and to all you clerks who cheat the United States all day long, to you I sing this song. Open their eyes that they may see glimpses of truth thou hast for thee. Place in their hands that wonderful key that will unclasp and set them free. Silently now we wait for thee. Ready our God thy will to see. Open their eyes, illumine them, Spirit divine. Yeah, I was in a Catholic church, and the little boy was in the back of the church, and he was reading the names on the wall, and the priest came by, and the little boy says, "What are all these names?" And the priest said, "Those are the names of our people who died in the service." And the little boy said, "Which service? 8:30, 9:30, 10:30? What does a report card teach a parent? You don't have to lift weights to raise a dumbbell.
You don't what?
You don't have to lift weights to raise a dumbbell.
Mom told me that?
No. superintendent of schools had a meeting of all of the principals and all of the teachers, and he said, our student body suffers from 7-dwarf syndrome. Every 7th kid is dopey.
That's a good one.
You're just saying, I want to get the lid. That's so pretty. That's a pretty, very pretty cake carrier. Now let's open
up in Walmart.
You did?
Yeah.
Not at the...
I have a nice glass one, but I didn't want to take.
You didn't get it at the side of the road?
No, this one I didn't get at the side of the road.
And what kind of a cake is this?
This is like your cake that I always make
Oh,
for
it's a
you.
lemon cake.
It's a lemon cake.
Oh, made in a bundt form.
Yeah.
Yeah.
Like we call it the Google Up. I'll put that on afterwards.
All right, yeah.
Because then it just...
That's good. Oh, thank
I
you.
made this early this morning. I made
How
a bunch
early?
of loaf ones about 5 o'clock. But you know, the thing is that I am still on hospital.
Welcome to the ladies' breakfast. This is the ladies' morning out. Right? We're at franchise. No men, right?
Yes, I know.
Oh, they did it so nicely. Coffee and juice are in the middle. Isn't it pretty? This is at the Kinderhook Reformed Church, Dutch Protestant Church.
But we didn't have enough lace, and we had to discard so many of the table. I went through them all yesterday. So many had holes in them.
Hi.
So this is the best we could do. And
Oh, I
the
think
other
it's
one-
nice. I'm looking.
This is my friend Ellie, honey. This is my friend Ellie.
I'm Nori.
And I'm Ellie Kissel.
Hi, I'm Jen.
You're going to be on television.
Now this is a good crowd, folks. We have a lot of people.
I'm just going to test and see if I can. I don't think they'll mind if I try to see if I can get Steve.
Oh no.
Just to see if he's.
Okay,
Now, there's plenty of room. Look that in here.
Today's vegetarian luncheon is coleslaw with Italian dressing, no mayo, it's an animal product, and a vegetarian hamburger on toast.
lips only, but with our whole lives, turning the duties, the sorrows, and the joys of all our days into a living sacrifice to you. Through our Savior, Jesus Christ, we pray. Amen.
This is the last legal paper of the week. There were 7 of them this week. U.S. Attorney, Idaho. Brian Julian. A judge hired a lawyer. Elliot Spitzer and Lisa Gardy. Caught lying and cheating. 2 judges, Lisi and Allman in the Providence Federal Court. Violated the U.S. Code, Section 636, 28, Title 28. James Reynolds, Mid-Hudson Cablevision, Rob Johnson, Laurie Pulver, Stuart Smith, and Mid-Hudson Media violate the public access laws and then refuse all legal papers and are in contempt of court. Chief Judge of the First Circuit, Boston, renders meaningless judicial conduct and disability complaints. Defendant Ayala cut a chat with Glendora from 2 hours to a half an hour. Courtesy copy, the United States District Judge before whom this action is in Idaho. Quayne Smith, a liar for hire for Sadly Stevens, Burke and Burke, Robert Callaghy. This is purportedly, I just really don't believe it. Rifkin, Radler, Contino, and Savarino. The clerk of the court. The original goes to the clerk. Defendants Diane Bennett and Alyssa Amato thought it was cute to drop a chat with Glendora from 10 p.m. Fridays, where he'd been for since 1993, to 4 p.m. And it isn't cute anymore. Defendants, the state of New York, its Supreme Court, its Appellate Division, and its First Department, and its Court of Appeals in care of Judith Kay, Chief Judge of the state of New York, for not allowing cameras in the courtrooms. In the people's courtrooms, not allowing cameras. That's carrying cover-up way too far. William Savino and Contino. There's Contino. Contino is a lawyer, Savino's a lawyer too, but Savino's a defendant and Rifkin Radler is a defendant for damaging public access in Kelly Burness versus Cablevision in Long Island, and therefore damaging Glendora's public access rights. Ernest Torres, DiMarzio clerk and McCabe clerk and Flanders clerk and intake clerk who lost $250 filing fee. Defendants Robert M. Callaghy and Sadly Stevens, Burke and Burke, with their ignorant law papers and their lying, caused Glendora a tremendous amount of time and dollars and ergs, and this is damages. Defendants Jane Doe, all Jane Does and all John Does and their abettors, who rob us of our blue sky, together with Stephen L. Johnson and the Environmental Protection Agency, with the jet that comes, the jet chemtrails full of poison that come into the sky and then down to you. Sandra Sotomayor, and Regina Raji and C.J. Hall, who are Second Circuit judges in Manhattan, said it was okay for McAvoy and Binghamton to deny the public access rights of Bill Houston and therefore of Glendora. And so they are being taken to court for violating public access law. Deborah Eacock, who started a lawsuit, she said she'd be Glendora's signer in Peekskill, and then she breached the contract. And Cecilia Masterilli and Christine Savarino, a pair of people who use extortion to chase away Glendora's signers so they don't have to cablecast their programs. And this is the judge before whom Glendora took Deborah Eacock, and this judge was improperly influenced and is now in the United States District Court in Idaho. And these people had to have 9x12 envelopes because there's so many defendants. This is Goodman, Coffey, DePiro, Emery, Felder, Hernandez, Klonik, Luciano, Peters, Pope, Ruderman, Savagno, and the New York State Commission on Judicial Conduct. By the New York State Constitution, you are to be protected from bad judges. It's their job to do it. They fail. So they are being sued. Many times they have been sued. Defendants: Flynn, Weiss, Bennett, Dunleavy, Galvin, Hume, Isabella, Shea, Figliosi, Dawson, and the New York State Public Disservice Commission for violating our rights to public access, the law. Now I will read you the paper. We will read you this great paper. And how are you tonight? This paper was written Friday, Saturday, and Sunday. It will be served tomorrow. Glendora plaintiffs, I told you all the defendants versus Stephen Taman, a judge, Deborah Eacock, Christine Savarino, Masterilli, et al. But what is this paper? Oh, by the way, take a look at this index number. It cost $250. This is Glendora Sur reply to Quain, a law firm in Idaho, and Callagee, Robert Callagee, a lawyer in Manhattan, Sadly, Stevens, Burke, and Burke, and they are in default. Eacock, Callagee, Satterley, Bennett, Amato, Savarino, Masterilli, they did not heed the Ninth Circuit mandate as to Rule 12 to dismiss a complaint equals Rule 56 to move for summary judgment. And that pro se civil rights cases such as this one cannot be summarily dismissed. Whatever they have to say this week should have been said the last week of December 2005. Sanctions on all of them. Grant Glendora default judgment, Rule 55, Federal Rules of Civil Procedure, and/or summary judgment, Rule 56, in her favor. Stop this motion practice and get down to justice. This is Omnibus 27. Bringing in the sheets. Isn't it fun? Isn't it fun to spend 28 hours doing legal papers? Now, Alpha, Whatever Quain, Smith, and Callaghy said in their paper of May the 5th, 2006, that would be last week, folks, should have been said the last week of December. Callaghy, Sadley, Eacock, Savarino, Masterilli, Oyala were served the complaint Christmas week 2005 with 30 days to answer. They chose not to answer. They chose fugitivism instead. They have no standing left. They are out. They are imposters, intruders, and fakers. They are in default and must take the penalty of pecuniary punishment under the wrath of Rule 55, Federal Rules of Civil Procedure, default judgment. All they had to do, folks, was to sign and date the waiver, Federal Rules of Civil Procedure, Rule 4D, and get 60 days to answer. With the papers, they should have answered the papers in the last week of December, but they answered them in the first week of March and the first week of May. Glendora just gets served. Her omnibus final paper by Glendora, Sir reply to Grisham motion to dismiss, and Toman Julian do not get another reply after Glendora's Sir reply to them. And what Savino, Rifkin, Radler say last week should have been said the last week of December 2005. All defendants are unambiguously in default, and Glendora is entitled to judgment by default. Sanctions on all the defendants and their alleged representatives of $10,000 pursuant to Rule 11 of the Federal Rules of Civil Procedure, and contempt of court on the James Reynolds defendants. That paper took, what was it, 28 hours and a whole lot more money. And that just went out Thursday. It was served Thursday. And fa-boom, this one comes in the mail. And it could have come in and gone out with the other one. But it added 28 hours work and $34. So I just get that other paper served when this one comes in. Then, this is why Callaghy and Sadley and all the other defendants, Sarok, why they all got sued for the damages that they caused. Then comes another paper, late paper from Callaghy, who is the great defaulter. And he does it again. And Callaghy had to pay Glendora $5,020 for default judgment in the White Plains City Court. Then he defaulted in the Supreme Court, County of Columbia, State of New York. And this one is at the tune of $23,000. That's Amaro and Bennett. Further, he is in default in federal courts all over the country. Whatever Quain, Callaghy, Eacock, Savarino, Sadley, Oyala, Bennett, and Amaro write, say, or do is adiaphorous. They have struck out. The game is over, and they have lost. No more motion practice. Get down to justice. Vader, even if they were not struck out, they cannot waive Rule 12, Federal Rules of Civil Procedure, dismiss. They did not comply with this court's notice to pro se litigants of the summary judgment rule requirements. This is mandated by the Ninth Circuit. The federal court in Idaho is in the Ninth Circuit. Defendant is required to file with its motion for summary judgment a statement of undisputed material facts. And they didn't do that. They didn't even address the charges against all of these judges that I sued. Rule 12 will be treated the same in pro se cases, says the Ninth Circuit, as is Rule 56 summary judgment. These people did not read Glendora's scrutiny of this mandate on pages 34, 35, 36 of Glendora's reply to Taman Julian. That went out 2 weeks ago. Postmark, April 28th. Glendora incorporates her Taman Julian reply together with her omnibus final paper reply that went out 2 nights ago, postmarked May 12th, herein, as if fully stated herein. We're up to page 3. Callaghy is misrepresenting. He has no Carmody weight proof of authority to represent Ecox, Cecilia Masterilli, Christine Savarino, Diane Bennett, Alyssa Amato, Jennifer Ayalo. He has no Carmody weight proof of authority to represent these people. I think he's faking. And this is sanctionable under Rule 11 of Federal Rules of Civil Procedure. In his paper received on March the 3rd, he did claim to represent Ecox. In this paper received, he did not claim to represent Ecox. In this paper received 511, he gratuitously throws in Ecox. Now this makes Ecox default within default. This is a surreply. There is no reply to a surreply. Do not pull a Taman Julian who did a reply to a surreply. It is time to end this motion practice. It is time to end this rhetoric. It is time to get down to justice. Callaghy, like all of the defendants, like all of their masquerading representatives, with ambience superficial and supercilious, do not address the gravamen. They eschew the merits, and they long desperately for a meritorious defense when there is none. And what comes next? A case not adjudicated on the merits can be brought again. Everything that Glendora wrote in her Greek Abecedarian of May the 11th applies to Callaghy and those he claims to represent. Fraud, court's bad name, they give the courts a bad name. The claim against the bond, you go after a judge's bond who took an oath to support the United States Constitution, doesn't, and so the bonding company sees that he's a bad risk and he doesn't bond him anymore. And inter alia, up to page 7, they each individually and collectively have committed fraud. In fraud, they trust. It is pathos. Now here's what fraud is. It's an intentional perversion of truth for the purpose of inducing another to give up something of valuable to him. To surrender a legal right. A fraud is a false representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed. and that which deceives and is meant to deceive another, so that he shall act upon it to his legal injury. Keep that in mind. That might happen to you. As Glendora teaches her TV internet audience, that's you, admit it, acknowledge it, say you are sorry, say you are ashamed, say you wish you had not done it, say it embarrasses you, say you will not do it again, say you will make good for it, and say you stand here ready to take your punishment and to atone and to restitute. Don't stand up in public and do this bad stuff of running away, making puerile rationalizations. Take it like a grown-up. It is not a new message. It is what John the Baptist did after 40 days, and that's what John the Baptist did. And then after 40 days in the wilderness, that's what Jesus Christ did. He came out and his first message was repent. And all of you did these wrongs to America for pay, like Judas Iscariot, and your Saldama is coming. Callaghy is a defendant. He cannot defend co-defendants. Sadly is a defendant. Sadly cannot defend co-defendants. Glendora planned it that way. So here come poor babies, Savarino through Ayala, Masterulli, Bennett, and Amato, thinking that they are being defended, and they are not. It is fraud against them and against Glendora and against Judge Lodge and against America. In fraud they trust. Big point, like all the other phony amanuenses who have come out of the ground this spring, Callaghy, Quain have no defense on the merits. They deal not with the gravamen. It is all penumbra and no core. And va-boom! Glendora wins on all points that they eschewed. Allocution. Write good papers now, because this case, we're on page 10, may very well be going to the United States Supreme Court. Glendora is saving up for it, and her amici curiae, friends of the court, are helping her. What could happen is that we will lodge briefly here, the name of the judge is Lodge. The Ninth Circuit does not know what it is doing, nor has it for a decade, and I've been in the Ninth Circuit for a decade. Of this has Glendora personal knowledge, but Glendora is saving up for the U.S. Supreme Court with the alms of her amici curiae. Defendants, pay not the impostors you have now, get new ones. Glendora drums up business for the unlicensed mob, and defendants, best of all, go pro se. You can do it much better. I'm telling these judges to go pro se, don't hire a lawyer. You can do it much better. Lambda, Glendora's memo endorsed of April the 4th, 06, is incorporated herein and is the truth. And see the next page. That's where I tell them anything that Savino and Rifkin Radler have to say in their late paper of the first week of April should have been said on the last week of December. They had 30 days to answer. That's when they should have defended, not wait until they were in default. 13 page. Glendora has endured Callaghy's frivolous, vexatious, tinny papers for 12 years. He has lost so many cases, one after another. It is hard to believe that Cablevision continues to pay him. If Cablevision does, its chairman, Charles F. Dolan, is in for a non-23A fiduciary irresponsibility action. Glendora has to find out if Callaghy is doing penance and paying for this by himself. As well he should. Glendora is a shareholder. Callaghy does not list all defendants. He does not serve all defendants. He does not serve Spitzer, the Attorney General of the state of New York, and his assistant guardian, nor any of the New York State defendants, like the New York State Public Service Commission and the New York State Commission on Judicial Conduct. Glendora just gets her omnibus final paper, reply to Grisham, motion to dismiss. 25 hours and $86. plus 3 hours of videotaping it for her TV stations and the world internet, when lethargic Callaghan, late as always, comes crawling in with another profligacy. He even fails at being alert, on the watch, ready, prompt, and vigilant. But alas, this is going to change, because Glendora is sending him, and Sadly, and Savino, and Masterilli, Bennett, and Amato, and Oyella, and Tailgater Ecock, vigorous thought waves to elevate them to being the 100% people that they really want to be. Amen, so be it, and solemnly ratified. Here is the docket. I brought the docket up to date. And here is a special docket for Plain Smith Callaghan, the paper I'm dealing with now. And look at this. When I made my vegetables today, look what the potatoes came in. Isn't that cute? Idaho potatoes. So I put that in for Judge Lodge and the U.S. Attorney out there in Boise. And here we are, a fortiori. With the greater force and all the more, even more certain and necessary, Glendora is to be granted all of the relief demanded in her complaint, which is $180 million. Her complaint of November the 26th, 2005. She is to be granted Rule 55, default judgment, or in the alternative, Rule 56, summary judgment. Sanctions on all defendants and their representatives, real or fake. The cost of this action, together with all other relief, just and proper. Dated May 14th, that's today. Anno Domini. This is Opus 1390. It took 17 hours, and it's $34, and the internet number, circa 4345-19, edition 19, 4346-20. 20 editions I have to do as soon as I say goodbye to you. Under penalty of perjury and so forth, that's the service. And that Glendora has told the truth, the whole truth, and nothing but the truth, so help her God, that the defendants have not. And the closing is, God be with you till we meet again. And no more motion practice. Let's have a moratorium on it. I'll sing that song to you. I can't sing it to them. God be with you till we meet again. Keep His loving arms around you. Let love's banner float something o'er you. God be with you till we meet again. Here's some jokes. The reporter asked the teacher, what are you 3 things you like best about being a teacher? And she says, motivating young people, shaping the next generation, and opening up young minds. And the reporter said to the next teacher, what 3 things do you like best about being a teacher? And she said, June, July, and August. Write an essay, the children were told, about the lives of children in colonial times. And the girl wrote, life for children in the colonial times was hard. They had to play their video games by candlelight. And what cultural contribution did the Phoenicians make? And the little girl said, Phoenician blinds. Do you know how you make a Venetian blind? You stick your finger in his eye. What is an indentured servant? The teacher asked. Said the boy, an indentured servant is a slave with false teeth. And the boy wrote on his essay that we breathe oxygen in the daytime and we breathe nitrogen in the nighttime. The teacher was trying to explain to the children the duties and responsibilities of the Vice President of the United States. Why, children, what would happen if the President of the United States should die this very minute? Who would get the job? And the little girl said, a Republican undertaker. Why did the lady become a kindergarten teacher? She likes to make little things count. The superintendent of school gathered all of his school principals and all of his teachers and intoned, "Our student body suffers from 7 dwarf syndrome. Every 7th kid is dopey." Bill said the teachers respected me when I was in school, and his mother says they had to. You were older. Did you know that old principals never die? They just lose their faculties? Hector says, "I don't want to go to school today." His mother, he was telling his mother this. He says, "The teachers don't like me. The superintendent doesn't like me. The kids don't like me. Even the custodians got it in for me." And his mother says, "You have to go to school today. You are well and healthy. And you have a lot to contribute. And besides, you are 46 years old and the principal." What does a report card teach a parent? You don't have to lift weights to raise a dumbbell. How are you folks doing? Are you your 100% selves? You can be your 100% selves. I don't have any happy books to give you, my dears. They are all given out. Unless we can find somebody rich. You think we can find somebody rich to print 5,000 happy books for us? Now this happy book on page 32, which is a pretty beige page, they're all different colors, the pages on the happy book. Colors are so important. It says to you, wouldn't you like to be as great as you possibly can be? Wouldn't you, folks? Think of how great you can be. Wouldn't you like to reach your full potential instead of limping around here at 10%? Just keep asking making your retreat each day and listening to God, and you will be. Just keep going and spending your time alone with God the first thing every morning. This promises that you will be. It is guaranteed. And out of the retreat, when you're moving around, using the body more than the mind, count pure thoughts. Are you up to 75 pure thoughts an hour? 5 hours a day? Easily. Easily. And every 15 minutes rejoice about something. Well, this ends it for 3 weeks. We've got 20 half-hour programs to put the titles on. Why, that will take 20 hours. And usually when I start it, I stay up all night with it. Well, your hymn. Blessed assurance, all is at rest. I am my Savior, are happy and blessed. Waiting and watching, looking above, filled with His goodness, lost in His love. This is my story, this is my song, praising my Savior all the day long. This is my story, this is my song, praising my Savior all the day